Afternoon or good morning. We're ready to proceed. Ms. Klein?
Good morning, Hinda Klein on behalf of the appellants, and I will just refer to
Sure,
them.
I'm not receiving any
Mazes.
sound.
Excuse
I'm
me?
sorry.
I'm going to refer to the appellants as Mazes as opposed to their full Greek names.
Okay.
You could hold on one second. I think Mr. Richards having trouble hearing us.
No, now I can hear. Sorry.
Okay.
Okay. All right, Ms. Klein.
We're
You
here
want to
on
reserve
one.
rebuttal time, I assume?
Yes, Your Honor, 5 minutes, please.
Yes, ma'am.
We're here on a single issue today, which is whether the trial court abused its discretion in enforcing the Greek judgment at issue because it was not rendered by a system and in a manner compatible with Florida due process protections, specifically those that are ordinarily afforded to defaulted defendants. The Uniform Out-of-Country Foreign Money Judgment Act is in 55.601, and it provides the grounds for non-recognition of a foreign judgment. Subsection 1 provides that an out-of-country foreign judgment is not conclusive if the judgment was rendered under a system which does not provide impartial tribunals or procedures compatible with the requirements of due process of law. And that's a de novo determination, one of law. The second ground is an abuse of discretion standard. In this case, an out-of-country foreign judgment need not be recognized if the specific proceeding in the foreign court leading up to the judgment was not compatible with the requirements of due process. Our argument today is very simple, and that is that we believe that the trial court was in error in determining that the standard that he should be analyzing this on was whether or not the Greek system was absolutely repugnant to the Florida system, when in fact the standard is whether or not the Greek system was incompatible with Florida law, and specifically the due process concerns that we have raised.
So Ms. Klein, just to be clear, you are proceeding under the argument that the Greek system as a whole is such that the Greek foreign judgment was not conclusive. And so we're not talking about the discretion of the trial court, but we're reviewing this de novo.
We have raised both that argument, Your Honor, as well as the discretionary standard. One involves whether or not the system is compatible. The second involves whether the particular proceeding at issue was compatible. So we've raised those in the alternative.
Okay, because I will tell you that the first one is going to be a really tough sell, regardless of whether the trial court said, you know, absolutely incompatible or regardless of the language that the trial court used. There is nothing in this record that shows that the Greek system employs procedures that are incompatible with the requirements of due process. Your clients had notice, maybe not the notice they wanted, but their duly appointed representative was afforded notice, and they were afforded an opportunity to be heard. That is their right to due process. That's what the Greek system allows them. So unless, I don't know what you could present to suggest that this was an error of law as opposed to an abuse of discretion.
I understand, Your Honor. Our concern was, well, they had the opportunity on appeal to raise the arguments that they would have raised had they not been defaulted. They were not entitled to a damage hearing at which they could introduce evidence and testimony. And that is inconsistent with the Florida rule governing the procedure after defaults, specifically 1.440C, I believe it is, which provides that even a defaulted defendant is entitled to 30 days notice and an opportunity to introduce evidence at a trial on damages, unliquidated damages, excuse me. So basically, our argument is the same under both standards. If the court disagrees that the Greek system as a whole is not incompatible, then certainly the procedures and the proceedings in this case were. There's the issue of whether or not the Mazas were entitled to introduce any evidence regarding their the damages that the plaintiff in this case sought. It's undisputed that they were not. The only thing they were permitted to do on appeal was to raise legal arguments.
Wasn't there, I recall that the Greek Court of Appeal itself said that evidence was presented. There was a reference to evidence. And unfortunately, I failed to pull up the order in front of me, but it seemed that the undisputed evidence presented at the hearing before the trial court indicated that they could have presented evidence to the Court of Appeals, Greek Court of Appeals, in addition to whatever argument they may have been allowed to make in the trial court.
I went back, Your Honor, last night and made sure that that was not the case. I think it on record page 11, which I believe is the Court of Appeals decision, and actually the Supreme Court opinion that was filed directly with this court. And both of them talk in terms of the defendants being able to submit any argument they chose, but nothing about any opportunity to submit evidence. Now, it may be that there was sort of a record on appeal of the trial court proceedings at which we were not present, but that wouldn't be the same as submitting the testimony and evidence in opposition to the damage judgment.
Well, what would have happened? And if the record doesn't say so, then just say it doesn't say so. If they had persuaded the Court of Appeals, if they had not been permitted to present evidence before the Court of Appeals, if they had convinced the Court of Appeals that they had a meritorious argument, what would have happened then? Does the Court of Appeals remand it to the trial court? I mean, do we know based on this record what happens?
We don't know based on this record.
Okay.
No. And Your Honor, I did want to also cite with respect to the argument issue, not only record 11, also record 274 in the transcript at 75 and 76. So essentially, our argument is very simple, and that is that under the Greek system and the Greek proceeding in this matter, we were not permitted a damage trial at which we could have disputed the amount owed, and certainly things like the attorney's fees, the interest, etc. And as a result, we believe that we have met our burden of demonstrating that the Greek system and the Greek proceeding are procedurally incompatible with the due process protections afforded under Florida law. And we would submit that as a result, the trial judge was in error in finding that this foreign judgment is enforceable in this state. And I would like to reserve the rest of my time for rebuttal.
Okay, thank you, Ms. Klein. Mr. Richard.
May it please the court, Barry Richard on behalf of Lewis Hotels. Let me begin by noting that the Greek Supreme Court did indeed mention that evidence had been presented, and it detailed what that evidence was. Of course, I recognize that the Mazas' argument is that whether or not evidence was presented, they weren't there because they didn't have appropriate notice. Their case is based essentially upon two allegations, both of which are flawed. The first is that this was a default judgment on unliquidated damages and the second was that they didn't receive due process notice. The first one is incorrect because this was not unliquidated damages. This was a tax that was adjudicated by the Greek administrative court at a hearing at which the Moseses did participate. They challenged the amount of that tax, which, by the way, has never been disputed in this case. They challenged it and they lost. And so it was clearly a liquidated amount by the time it reached at the Greek appeal and by the time it reached the Florida court.
And Mr. Richard, the argument they made in conjunction with the tax, if I recall correctly, and correct me if I'm wrong, was that they had already paid it and therefore there was no basis for the hotel to pay it and then come after them for it. Am I correct in my recollection?
That's correct, Your Honor. And that was adjudicated in Greece and they lost. And it was affirmed by the appellate Greek court and by the Greek Supreme Court. So by the time it reached Florida, it was clearly a liquidated amount. But in any case, even an unliquidated amount is enforceable in Florida if the party received adequate due process notice, which they definitely received. The Greek law requires that a non-resident, which the Moseses are and were, name an agent in Greece for receipt of a process and of notices. And the contract that the parties entered into, the parties to this case, also required that. Greek law also provided that if for any reason the agent name ceases to be the agent, that it must be replaced. In this case, it's while the Moseses argue, they don't argue, by the way, that he was ever replaced or that he ever left. All they stated was that he ceased to be an employee of their company. But it's undisputed that he never ceased to be the agent, certainly not in the Greek records, and it's undisputed that they never replaced him. So, and that, by the way, is also what the contract required. So as far as the contract between these parties are concerned, as far as Greek law is concerned, the agent remained the agent, and it's also undisputed that service was made upon that agent. The Moseses argue that at some point that he refused to accept service, but that doesn't change the fact that he was served. You can't avoid a judgment by just refusing to accept service, and he was an extension of the Moseses once he was named as their agent for receipt of service. So there is no question that, and this question comes ultimately down to due process. And as Your Honor pointed out, this was clearly due process. It doesn't even have to be the same process as Florida, although Florida, I believe, would have come to the same conclusion, which is that they received notice. It's a fundamental principle of jurisprudence that you cannot avoid a judgment simply by not showing up. I might notice also that it's agreed that all arguments were available in the appellate Greek court, although the record is not clear as to whether or not evidence could have been introduced, but that wouldn't make any difference for purposes of this case. There is no argument in this case that there was insufficient service on the agent. There is no argument that there was a lack of personal jurisdiction. There is no argument that there was any lack of due process other than the issues that I've discussed. And there is no suggestion that the Greek system in general does not provide adequate due process. And we've cited several cases in the United States that have recognized that the Greek system does afford adequate due process. So, Your Honors, unless there's questions, we think that this case is simple, it's clear, and nothing has been suggested to this court that would require a reversal of the lower court's well-considered decision.
Thank you, Mr. Richard. Ms. Klein, rebuttal.
Very briefly, I did go back and I looked at the record regarding Judge Rothstein, your question regarding the ability to introduce evidence. And again, it looks at the record on page 11 and the looks like the 5th page of the Supreme Court indicates that it looks like the evidence that was before the Supreme Court was that which was before the trial court, and that the appellant was only entitled to raise arguments on appeal.
Well, let me ask you this, Ms. Klein, because I went back also. And I know that page 11 talks about that the party is allowed to bring whatever arguments it may have raised before. On page 33, it says, following the evaluation of the evidence submitted to this court, and in particular, all the documents lawfully submitted by the litigants, either as independent evidence or as evidence to be considered by this court, and then it goes on and on. So that certainly suggests that there is evidence being submitted by the litigants to that court. Maybe that's not what it means, but it certainly could mean that. And as the appellant, you have the burden of establishing error. So to the extent that anybody interpreted that to mean that evidence could be considered by the Court of Appeals, I think you have the obligation to show that that's not what it means.
That Your Honor is correct.
Or
Regardless
that
of,
it matters, you know.
well, at issue really is whether or not there was any kind of litigation regarding the amount of the judgment that was ultimately rendered in favor of Lewis Hotels. And it's been admitted in the answer brief that not all of the judgment was liquidated damages. And there's nothing in any of the appellate rulings, whether it be the Court of Appeal or the Greek Supreme Court, that really addresses that issue at all. We certainly have never disputed before this court any of the arguments that Mr. Richard has raised regarding the service of process and jurisdiction, et cetera. Our appeal in this case is very narrowly focused on whether or not the Greek system has protections similar to Florida law regarding how to litigate damages after a party is defaulted on liability.
Well, and are we sure that that's what 55.605 requires? I know if you look at J, was it 2J? Yeah. The specific proceeding in the foreign court leading to the judgment was not compatible with the requirements of due process of law. Now, I don't read that to say that the specific proceeding in the foreign court did not permit the opportunity to challenge liquidated damages at the trial level as they might have been allowed to do under Florida law. Those are two very different requirements. I don't think we're requiring foreign courts to comply with Florida rules of civil procedure before we can acknowledge their judgments. So what exactly is required under J? I mean, what?
Well, J itself is very amorphous. It is not specific insofar as defining what an incompatible proceeding would be. In Florida, it's not simply a matter of a rule of civil procedure. The Florida courts are very firm in finding that the failure to provide a defaulted party the ability to litigate damages is a serious matter and a breach of due process, such that any resulting judgment is absolutely void.
And
Now,
do we in fact have a defaulting party here?
Excuse me, Your Honor?
Do we in fact have a defaulting party here? I mean, once they have the opportunity, they had notice, there's no question, they had an opportunity to be heard. Are they properly characterized as a defaulting party?
Well, they were defaulted at the trial court level, I suppose, on appeal, because they were permitted to raise arguments unlike they would be able to in the Florida courts. I guess it would not be a technical default as that term is defined under Florida law, but there's nothing in the Court of Appeals order or the Supreme Court order that indicates that there was any discussion as to the amount of damages or attorney's fees or interest or fines, etc. So I did conduct nationwide research trying to find something more specific to Greek law. Mr. Richard is correct that there are some cases involving forum nonconvenience issues that have found it not inconsistent with Florida law. But other than that, there haven't been any cases nationwide addressing whether or not the proceedings in a Greek court with respect to the assessment of damages after a party has been precluded from litigating the merits. When I say litigating, I mean introducing evidence, testimony, et cetera. There's nothing precisely on point. And the way the statute is written, it's extraordinarily broad, and it's for that reason, I think it's certainly in the eye of the beholder. But I would submit that given how strict Florida law is on reversing cases where a party has been denied its right to litigate the amount of damages, I submit that at the very least, the proceeding in question was incompatible with Florida law. And I would request that this court reverse the order on appeal.
Thank you, Ms. Klein. Thank you, counsel. That'll conclude today's docket, and we are in recess.